Many foreign investors and companies operating in Vietnam rely on non-disclosure agreements to protect confidential information. But when a breach happens, one critical question arises. Can you actually sue for breach of NDA in Vietnam? The short answer is yes. But the legal reality is more complex than most expect. Because filing a claim is only the first step. The real challenge lies in proving and enforcing your rights in practice. Under Vietnamese law, NDAs are generally recognized as valid civil agreements. This means that if one party breaches confidentiality obligations, the other party has the right to initiate legal action. Claims are typically based on breach of contract under the Civil Code. In some cases, they may also involve provisions related to trade secrets or unfair competition. However, having a legal basis does not guarantee a successful outcome. To succeed in an NDA dispute in Vietnam, the burden of proof lies primarily with the claimant. There are several key elements that must be demonstrated. First, that the information in question qualifies as confidential. Second, that the NDA clearly defines obligations and restrictions. Third, that the defendant actually breached those obligations. And finally, that the breach caused damage. If any of these elements are missing, the claim becomes significantly weaker. One of the most common issues in NDA disputes is the definition of confidential information. Vietnamese courts often require specificity. Vague or overly broad definitions may not be sufficient. For example, stating that all company information is confidential may not be enforceable. Instead, effective NDAs identify clear categories such as client databases, technical data, pricing strategies, or proprietary processes. This clarity is critical for enforcement. Even if the NDA is well drafted, proving a breach can be difficult. You must show that the defendant accessed, used, or disclosed confidential information without authorization. This requires evidence, such as emails, data logs, communications, or business activities linked to the misuse of information. In many cases, companies suspect a breach but cannot prove it with sufficient certainty. This is where many claims fail. Vietnamese courts will also assess whether the breach resulted in actual damage. This could include financial loss, loss of clients, or competitive harm. But it is not enough to simply claim that damage occurred. You must establish a clear link between the breach and the loss. Without this connection, compensation may be limited, even if a breach is proven. If a claim is successful, several remedies may be available. These can include compensation for damages, contractual penalties if specified in the NDA, and in some cases, injunctive relief to stop further disclosure. However, the effectiveness of these remedies depends on the strength of your evidence and the structure of your agreement. In practice, financial recovery may not always fully reflect the actual business impact. Many NDA lawsuits in Vietnam fail due to avoidable issues. Some agreements are too vague. Others lack clear enforcement mechanisms. In many cases, companies fail to demonstrate that the information was properly protected internally. And in others, evidence of breach or damage is insufficient. These gaps significantly reduce the likelihood of success. The key to enforcing an NDA in Vietnam starts long before any dispute arises. Companies should implement clear internal policies for handling confidential information. Access should be controlled and documented. Sensitive data should be clearly identified and protected. At the same time, NDAs should be drafted in alignment with Vietnamese law, not copied from foreign templates. Preparation is essential for enforcement. For foreign investors in Vietnam, confidential information is often one of the most valuable assets. This includes client relationships, operational processes, and strategic plans. If these are not properly protected, the consequences can be significant. Understanding whether and how you can sue for breach of NDA in Vietnam is a critical part of risk management. At LTS Law, we support foreign investors and companies in Vietnam not only in drafting NDAs, but also in preparing for enforcement. We assess legal risks, structure agreements for enforceability, and advise on evidence and dispute strategy. Our approach focuses on turning legal documents into practical protection. Yes, you can sue for breach of NDA in Vietnam. But success depends on preparation, documentation, and legal strategy. Before relying on any NDA, it is essential to understand how it will perform in a real dispute. Visit lts.com.vn to consult with our legal team and ensure your NDA strategy in Vietnam is built for enforcement, not just appearance.